Judge John Roberts. Tries to humiliate Karoline Leavitt, then discovers she is a legal genius. The tension in the courtroom was palpable as Chief Justice John Roberts leaned forward, his steely gaze fixed on the young attorney standing before the Supreme Court bench. Karoline Leavitt, a 25-year-old lawyer with a reputation for fiery rhetoric and unshakable confidence, had just begun her oral arguments in a high-stakes First Amendment case. What unfolded next would become the stuff of legal legend, a clash of wits that left even seasoned spectators breathless. Roberts, known for his incisive questioning and no-nonsense demeanor, interrupted Leavitt barely a minute into her presentation. "Counselor," he said dryly, "perhaps you could start by citing any precedent that supports your creative interpretation of the Constitution?" The jab drew muted chuckles from the gallery. Leavitt, undeterred, paused for a beat, her expression calm. "Certainly, Mr. Chief Justice," she replied. "I direct the court to Reno versus ACLU, 1997, which affirmed that online speech is entitled to the same protections as print media. But if I may, the real precedent lies in Justice Holmes's dissent in Abrams versus United States, the notion that truth emerges only through free trade in ideas." The room fell silent. Roberts raised an eyebrow, then volleyed back with a series of rapid-fire questions, probing obscure rulings from the 19th century. Leavitt didn't flinch. She cited Stromberg v. California, 1931, quoted Learned Hand's Spirit of Liberty doctrine, and even corrected Roberts's misstatement of a holding in Brandenburg v. Ohio, politely noting, "With respect, Mr. Chief Justice, the imminent lawless action test applies to incitement, not mere advocacy." By the third exchange, the dynamic had shifted. Roberts's earlier skepticism gave way to a faint smile. "You've clearly done your homework, Ms. Leavitt," he conceded, as Justice Kagan smirked and Justice Sotomayor nodded in approval. What began as a test of endurance became a masterclass in constitutional law. Leavitt dissected the government's case with surgical precision, weaving historical context from the Sedition Act of 1798 to modern digital activism into a narrative that left the justices scribbling notes. The climax came when she quoted Roberts's own words back to him from a 2006 confirmation hearing. "Judges are like umpires. We don't make the rules. We apply them." Leavitt tilted her head. Respectfully, isn't this case about ensuring those rules evolve with the tools of free expression? Roberts leaned back, momentarily speechless, before offering a rare courtroom compliment. "Well played, counselor." By the time Leavitt returned to her seat, the gallery buzzed with disbelief. Legal analysts later called it one of the most dazzling oral arguments in recent memory, while Twitter erupted with clips of her shutting down a Supreme Court justice. Critics who dismissed Leavitt as a political provocateur suddenly praised her depth and restraint. Roberts, in a private conversation later reported by CNN, allegedly told a clerk, "That woman could teach me a thing or two about the First Amendment." The case United States versus Free Voice is still pending, but Leavitt's performance cemented her status as a legal force. Behind the scenes, clerks whispered about her preparation, a reported 18-hour daily study regimen in the weeks leading up to the hearing. Colleagues revealed she'd memorized every Roberts opinion on free speech since 2005. She wasn't just ready for him, one observer noted. She invited the confrontation. In the end, the real victory wasn't just tactical. It was symbolic. A 25-year-old woman, underestimated by the most powerful judge in America, turned a potential humiliation into a triumph of intellect and poise. As Leavitt told reporters afterward, the Constitution doesn't care about your age, your pedigree, or who's in the room. It cares about principles. My job was simply to remind them.